Sit down, and then if the time permits, we'll take up your case. Yes, DP saying.
Matter relates to dismissal.
Huh?
The matter relates to dismissal from services of the employee.
Ah.
The appellant husband was the employee in the department of the Madhya Pradesh Madhya Vitran Company.
Huh?
Madhya Pradesh Madhya Vitran Company.
You are working as.
Appellant husband.
Acha, my husband.
As helper grade 2.
Acha.
Helper grade 2. His services were terminated after due departmental inquiry in 2010. Husband has preferred an appeal that was dismissed by the appellate authority. Preferred a writ petition. And writ petition, because the writ court has come to the conclusion, the inquiry which was conducted by the inquiry officer is beyond any because of there is no evidence in respect of the allegation. In respect of the allegation, there is no clinching evidence available in the inquiry. And the court has given the finding that the appellate authority has passed a non-speaking order, and in the meantime the development because of the husband was died. The court has case remanded back to the appellate authority for reconsideration, keeping it with the lenient view. The P22 is the order of this honorable court of the court.
No, that's okay. Then what happened?
In first round. But
then what happened?
After the remand, the appellate authority again dismissed the appeal without considering the observation made by the Honorable High Court in the first round of litigation, and failed to take a lenient view. And given the finding that because of the employment which gained by the appellant husband based on the forged mark sheet, so this finding was already been considered in earlier round of litigation. London Writ Court, without issuing any notice, dismissed the writ petition, given the finding that because of the husband has not challenged the order of dismissal in his lifetime, and only the widow is come forward.
Now, when was the order? When was the order passed by the authority after remand?
2018.
And when did your husband die?
2013. 2013. During pendency of the writ petition.
No. First writ petition was decided when?
2018.
18.
Sir.
And when your husband died?
2013.
So after 13, you have challenged. Were you substituted?
I was substituted as legally. So the writ court has considered this aspect and considering the finding of.
तो मामला यह है कि पति का देहांत हो चुका है, उनका टर्मिनेशन हुआ था, फोर्ज मार्कशीट की बात है, उसको चैलेंज कर रही है पत्नी। 13 में ये हुआ और 18 में ये रिट पिटीशन पहले हुई, तो उसमें आशातीत क्या कहना चाहिए, परिणाम या निर्णय नहीं मिले तो आए हैं।
Officer or the order of dismissal, the disciplinary authority, the court has come to the conclusion in the writ petition para 13 and 14 manner that the finding recorded by the inquiry officer is perverse. In respect to the forged mark sheet, the finding is based on no evidence, and the case was remitted back to the appellate authority for reconsideration of the issue, taking a lenient view, reducing the penalty of dismissal as compulsory retirement or the reduction of pay scale.
Now, where is that order of the High Court?
P22.
Where? Why should you not file it?
I will cross it the order of the court.
दिखाइए। Yes.
महत्वपूर्ण आदेश है, इसका रिकॉर्ड पर होना अति आवश्यक था। जज साहब ने देख लिया, अदरवाइज वो फिर लगता और फिर ऐसा भी हो सकता था।
Where is the last?
Para 13. It is also submitted that when the punishment proposed was of reduction to the lower time scale of compulsory retirement, as the petitioner has already put in service 22 years of service on the date of the passing the order of penalty, then the appellate authority was required to apply its fine that why more severe punishment has been inflicted by the disciplinary authority. All these facts have since not been considered by the appellate authority, and as is apparent from the various inquiry reports and the material which was produced by the inquiry officer, that they could not successfully prove production of any mark sheet by the petitioner, and therefore it could not have been said that the petitioner committed any fraud or delinquency by producing a forged mark sheet to obtain any appointment. And when it is mentioned by the executive engineer himself that at the relevant point of time when the petitioner was given appointment, no qualification was prescribed for appointment as a labor, this court is of the opinion that the finding.
तो ये एज ए लेबर की नौकरी रही, कोई क्वालिफिकेशन इसमें रिक्वायर्ड थी नहीं। फोर्ज मार्कशीट के मामले को भी कोर्ट के डिसीजन में आ रहा है कि वो उस तरह से साबित नहीं हुआ, उन्होंने कहीं अपने ऐसा कोई कागज लगाया ही नहीं।
Recorded by the disciplinary authority in subsequent inquiry that the petitioner has produced a forged mark sheet was beyond the scope of inquiry, because until and unless it was proved that such mark sheet was produced by the petitioner and petitioner employee had obtained appointment on the basis of such forged mark sheet, petitioner could not have been declared to be a delinquent in the matter of production of a forged mark sheet. In view of such facts, and also the fact that the appellate authority has failed to consider the various aspects reproduced as contained in Rule 27(2) of the Rules of 1966, it cannot be said that there is an actual and complete compliance of the provisions contained in Rule 27(2) of the Rules of 1966. Therefore, the impugning order deserves to be quashed and is quashed. It is directed that the appellate authority shall apply its fine afresh on the issue raised before this court and which were available before the appellate authority, as have been reproduced above, and pass a fresh order within 30 days, and shall also take into consideration two facts.
Now, where is the order of the appellate authority?
P1 is the order.
जो विभाग में ही अपील कर सकते हैं वो जो अपीलेट अथॉरिटी होगी, वहाँ पे भी जब उन्हें अपने मनचाहा निर्णय नहीं मिला था, उसको क्वैश किया था हाई कोर्ट ने। और अब देखते हैं यहाँ पर क्या होता है। दोनों जज साहिबान बात कर रहे हैं। फैक्ट्स का
External page 7 of the appellate authority.
तथ्यों को देखा जांचा परखा जा रहा है। बहुत महत्वपूर्ण प्रक्रिया न्याय व्यवस्था की। बारीकी से चीजों को देखा समझा जा रहा है। लगता है
You read your statement before the authority at page 31.
अब देखिए इसमें क्या है।
Top
30 sir.
31.
Page 31.
जो रेड कलर से 37 लिखा है। He never produced such certificate.
Right. And
Then-
he never produced such certificate. Then he was asked to give his actual certificate, which he was unable to do. Then he was asked that from which school he studied in class 6 to 8, so that his claim may be verified. To which his reply was that he does not remember the name of the school. After a few more dates, the inquiry was held on 28th of May 2010. On that date, in presence of defense representative, the employee voluntarily admitted that he passed class 8 examination from Asa Gandhi School, Machan district in 1970. On 28th of May 2010, the inquiry proceeding was concluded. In view of the above statement of the employee, and in view of the fact that the employee could not present any other mark sheet certificate of class 8, in my considered opinion, no infirmity can be found in the finding of the inquiry officer dated 15th of June 2010 in relation to supplementary charge sheet dated 24th of Feb 2010. The appointment was
सही तो है, गलत क्या?
kindly see.
भाई आपने जो मार्कशीट पेश करी है और स्कूल कुछ बता रहे हो, मार्कशीट कुछ बता रहे हो।
मार्कशीट तो इंक्वायरी का पार्ट ही नहीं था, उसमें तो इंक्वायरी हुई नहीं है।
कौन सी चार्जशीट है आपको?
Yes.
तो आपकी मार्कशीट कौन सी है? आपने कहाँ लगाई है मार्कशीट?
But kindly see that finding of the inquiry officer.
No, you show me the marksheet which you have produced.
That mark sheet is not part of this petition, brother.
Naturally,
Because
because
two charge sheet were issued.
you have to first demonstrate what was your statement before the inquiry officer
Correct.
and what was the document you have filed. Then we will see the inquiry report.
Sir, मेरा एक submission because of the husband was died in 2013.
No, जी, I will not sacrifice judicial discipline.
जो इंक्वायरी ऑफिसर की ब्रीफ है सर, वो तो मैंने पेश की है।
You please show me that this was my statement before inquiry officer and this is document I have filed.
सच my report की अगर वो
There's no problem because we will not casually upset the order because we have also some limitations.
मेरा केवल इतना
We cannot stretch out.
So if lordship is given liberty because of I can refer, then only the inquiry brief. अगर वो we only want to know because this observation of the authority after remand. Sir.
Relates to that you did not disclose the fact as regards your passing of examination from any school, and therefore let us see of which school you have produced the mark sheet.
After
because you produce it or please what
मामला थोड़ा सा यहाँ से इस तरह का लग रहा है कि मार्कशीट उन्होंने दी और जो मार्कशीट में स्कूल है और किस स्कूल से तुम पढ़े थे ये जो स्टेटमेंट दिया इसमें फ़र्क है। और जैसा आप कह रहे हैं कि मुझे ये दो चीज़ें दीजिए जो आपने वहाँ की अपेलेट अथॉरिटी को दी थी, यानी बयान और मार्कशीट दीजिए तो हम आगे बात करें। वकील साहब कह रहे हैं कि सर अपेलेट अथॉरिटी के ऑर्डर पे बात करिए, करना चाह रहे हैं, करवाना चाह रहे हैं। जज साहब नहीं मान रहे हैं।
Listen,
सितंबर पे गया।
Unless you produce that, we will not interfere.
चलिए।